Hi friends, welcome to Neo IAS Prelims 2019 Last Lap. So this is a new venture by Neo IAS. Here we are exclusively targeting Prelims 2019. Neo IAS has always been coming up with new ideas to help you out to be successful and achieve your dreams like Lucid Mains, Speed Economy, Focus Prelims, etc. And this is another such step to help you get through Prelims 2019. So, going through the last few years of UPSC pattern of questions, we can understand how important current affairs are for the exam. So, this time we are bringing to you the current affairs of last 15 months in episodes just to make things easier for you. And today we are starting with polity and governance. So, we will cover the entire polity and governance of 15 months plus the associated static information. And if this seems to be helpful, we will be bringing to you all other subjects as well, but that depends on your feedback and support. So I hope this is going to be your exclusive current affairs material for Prelims 2019. Okay, so be confident and all the very best. So let's begin our first step for Prelims 2019. Those who haven't yet started, no worries, you still have time. Actually, you have more than 100 days. So today we will cover the polity and governance part from January, February and March of 2018. So let's start our last lap. We'll begin with National Voters Day. The Election Commission of India celebrated 8th National Voters Day across the nation on January 25th for enhanced participation of citizens in the electoral process. So the National Voters Day was initiated in 2011 to commemorate the foundation day of the Election Commission of India. And the Election Commission of India came into existence on 25th of January 1950. So that is the reason why we are celebrating the National Voters Day on this 25th of January. And this day is also utilized to spread awareness among voters regarding effective participation in the electoral process. And regarding the key facts of this 8th National Voters Day is that this year's celebrations revolved around the theme of accessible elections. So when we hear something like accessible or something related to that, we should think it is related with disabled people. Like we have the Accessible India campaign. So this accessible elections is also related to disabled persons. That means that this expresses the Election Commission of India's pursuit of working towards making the electoral process more inclusive and friendly for the disabled population. So that is the accessible elections theme. And we have another thing known as Voice India. So what is Voice India? And on the occasion of National Voters Day, the President also inaugurated the first edition of Voice India. It is a biannual magazine which brings forth best practices, innovations and knowledge which is derived from practical experience and success stories of the election machinery which exist in every corner of the nation. That's all regarding the topic. Now we have the Prevention of Insults to National Honor Act of 1971. So why is it in news? The Supreme Court revised its earlier order and national anthem is not mandatory in cinema halls now. So we all know that. The earlier order came on a writ petition which referred to the Prevention of Insults to National Honor Act of 1971, and that's the reason why we are discussing it now. The Act was legislated to prevent dishonor to national symbols, and this national symbols include the Indian Constitution, the National Anthem and the National Flag. Also, the Act is in consonance to Article 51A of the Indian Constitution. So, Article 51, we know that it is the fundamental duty. So, the Article 51 of the Indian Constitution lays down the fundamental duty to respect and abide Constitution, National Anthem and the National Flag, and the President, Vice President, Prime Minister, Speaker of the Lok Sabha, etc. They are all liable for disqualification upon committing any violation of the Constitution under this Act, and this is to be read along with sections 7 and 8 of the RP Act of 1951, which means that the RP Act, the Representation of the People Act 1951, it also mentions about a disqualification on these grounds. So, what are the punishable offences? In the case of National Anthem, whoever intentionally prevents the singing of the National Anthem or causes disturbance to any assembly engaged in singing of National Anthem, they shall be punished with imprisonment up to 3 years. And in the case of National Flag, intentionally showing disrespect like putting any kind of inscription on the national flag, etc. They are all punishable offences. Now, the next topic is office of profit. The Election Commission recommended to the President to disqualify 20 Aam Aadmi Party MLAs for holding the office of profit, and the President is bound by the Election Commission recommendation. So, what is an office of profit? If an MLA or an MP holds a government office and receives benefits from that office, then that is termed as an office of profit. And a person will be disqualified if he holds an office of profit under the central or state government. However, certain offices are exempted from the office of profit by law. Persons holding such offices, they will not be disqualified. And for example, the chairperson of National Women's Commission can be an MP or MLA. So in that cases, it doesn't lead to disqualification. But the word office has not been defined in the Constitution or the Representation of People Act of 1951. That is an important point. The word office, it has not been defined in the Constitution or even in the RP Act. So we can state certain articles in which this office of profit is mentioned, but a clear definition is not given. So the articles are Article 102, Article 103 and even Article 191. So Article 102 says that a person shall be disqualified from being a member of either House of Parliament if that person holds any office of profit among other grounds. And Article 103 says if a question arises whether a member has incurred such a disqualification, disqualification regarding to the office of profit, it will be referred to the President's decision and the President shall obtain the Election Commission's opinion. So that's why I said earlier that the President is bound by the Election Commission recommendation. And regarding Article 191, it contains a similar provision for MLAs and MLCs, legislative assemblies and legislative councils in the states. So legislators in Delhi are covered by corresponding provisions in the Government of National Capital Territory Act of 1991. So just mention for knowledge. And the idea behind such a rule is that when a legislator is taking up a government office, he can be bound by government pressure. And actual purpose of legislators is to keep in control of the executive. Therefore, holding a government position, it violates the principle of the separation of power. So, since we mentioned about disqualification, what are the other ways of disqualification for MPs and MLAs? It's mentioned in the Constitution, that is being of unsound mind, being an undischarged insolvent and not being an Indian citizen or for acquiring citizenship of another country. So, these are the other grounds for disqualification. Next topic is MP Lads. MP Lads means Members of Parliament Local Area Development Scheme. So, this is actually a scheme. The Cabinet Committee on Economic Affairs has given its approval to continuation of the MP Lad scheme till the term of the 14th Finance Commission. That means till March 2020. And this is actually an ongoing central sector scheme which was launched in 1993-94 period. And the scheme enables the members of parliament to recommend works for creation of durable community assets. And this should be based on locally felt needs like drinking water, education, public health, sanitation, roads, etc. And under the scheme, each MP has the choice to suggest to the district collector for work to the tune of rupees 5 crores per annum to be taken up in that MP's constituency. And it should be noted that not just the Lok Sabha MPs, but the Rajya Sabha MPs or even the nominated MPs, they can recommend the same. So that is an important point to be noted for prelims. Lok Sabha MPs, the Rajya Sabha MPs or even nominated MPs can recommend the same. The Rajya Sabha MPs can recommend works in one or more districts in the state from where he or she has been elected, and the nominated members of the Lok Sabha and Rajya Sabha, they may select any one or more districts from any one state in the country for implementation of their choice of work under the same scheme. So, next topic is Constitution Bench. So, Constitution Bench is to look at adultery law, and that's why it came into news. So, Constitution Bench, it is the name given to the benches of the Supreme Court of India, which consist of at least 5 judges of the court which sit to decide any case involving a substantial question of law as to the interpretation of the Constitution of India. And this provision has been mandated by the Article 145 of the Constitution of India. And what the Article 145 says is that any matter that involves a substantial question of law as to the interpretation of this Constitution, it should be heard by a bench of not less than 5 judges of the Supreme Court. So this is what is commonly referred to as a constitutional bench. Now, who can constitute such a bench? The answer is that the Chief Justice of India. The CJI has the power to constitute a constitution bench and refer cases to it. The constitution benches, they have decided many of India's best known and most important cases such as A.K. Gopalan versus State of Madras, Keshavananda Bharati versus State of Kerala, which means the basic structure doctrine case, and Ashok Kumar Thakur versus Union of India for OBC reservations, etc. So all these have been decided by Constitution Bench. Now, IPC or Indian Penal Code. The Supreme Court has referred to a larger bench, a writ petition, which was filed by members of the LGBT community to strike down the colonial section 377 in the Indian Penal Code. So, section 377 has been in use for a long period of time, and as you know, section 377 criminalizes homosexuality. So, the Supreme Court observed that social morality changed with time, and part of the problem is attributed to the age-old Indian Penal Code. So, the Indian Penal Code was designed in 1860. So, that is why we are discussing the Indian Penal Code now, and for prelims, knowing IPC is important. So, let's just have a look on few facts related to IPC. So, we need to look upon certain things like who drafted the IPC, how was they inspired, and just a brief history. So, the Indian Penal Code was drafted by the first Law Commission of pre-independent India, and this body was presided over by Lord Macaulay. So, that was the first thing to be learned, who drafted. The next is related to inspiration. They drew upon not only English and Indian laws and regulations, but also Edward Livingston's Louisiana Civil Code of 1825 and even the Napoleonic Code. Those were the inspirations. And then regarding a brief history, the draft code was submitted to the Governor General of India in 1837 and it was passed in 1860. So, the Indian Penal Code came into operation on 1st January 1862. So, that's why it said the age-old Indian Penal Code. It came into existence on 1862. And the offences described in the code, they fall into two categories. So, they are the offences against the state and the public and offences against person and property. So, these are the two categories of offences. As I said, the offences against the state and the public and the offences against person and property. And one really important point to be noted is that it is not applicable everywhere. Indian Penal Code is not applicable throughout India. It is not applicable in Jammu and Kashmir. That is a really important point to be noted. The story is that after the partition of the British Indian Empire, the Indian Penal Code was inherited by its successor state. That means the Dominion of India and the Dominion of Pakistan. And in Pakistan, it continues independently as the Pakistan Penal Code. So, in Jammu and Kashmir, it is the Ranbir Penal Code or the RPC. It is applicable in Jammu and Kashmir. And this Ranbir Penal Code is also based on this code. Now, regarding some of the important sections of IPC which appears in news, we can just go through these important sections. So, first is IPC 124, sedition. IPC 141, unlawful assembly. IPC 300 is murder. IPC 375 is rape. IPC 377, which we just mentioned, is unnatural offences or homosexuality. Then IPC 497 is adultery. And this is what we were referring to in the initial discussion. Recently, Supreme Court refers to the Constitution bench plea against penal law on adultery. And then comes IPC 498. Husband or a relative of husband of a woman subjecting her to cruelty. And the issue of women's rights and family law reform. So, that is IPC 498. And IPC 499 is defamation. So, these are the important sections of IPC which frequently appears in news. So, just mentioned for knowledge. Next, we have sessions of parliament. So, why do we discuss sessions of parliament as a news? Because the opposition parties hit out at the government for a short budget session of parliament. So, we need to discuss the sessions of parliament. Let's see some details about that. a session of parliament is the period which is spanning between the first sitting of a house and its prorogation or dissolution in the case of Lok Sabha. So that is a session of parliament. Then the Indian parliament ordinarily meets in 3 sessions in a year. So these 3 sessions are, one is budget session, then monsoon session, and then comes winter session. So the budget session is between February and May, monsoon session July to August, and winter session November to December. And the sessions of parliament, they are convened at the discretion of the president, and the president has the power to summon or prorogue either or both houses of parliament. But the only thing to be remembered is that there should not be a gap of more than 6 months between 2 sessions. So we already said the president has the power to summon or prorogue either or both houses of parliament, but the power of adjournment, it belongs to the respective presiding officers. So what is the difference between adjournment and prorogation? Adjournment of a house, it does not terminate the session of the house. It merely postpones the proceedings of the house to a future date. But prorogation brings an end to a session of the house. So that is the difference between adjournment and prorogation. Now we have Conference of Governors. So the Governors' Conference, it is an extra constitutional device for securing cooperation and coordination between the states in India. And it is chaired by the President of India. The Conference of Governors is chaired by the President of India. And 48th such conference was held in Rashtrapati Bhavan in October 2017. Next we have All India Whips Conference. All India Whips Conference took place in 2019 in Udaipur, Rajasthan. And this conference was organized by the Union Ministry of Parliamentary Affairs along with the government of Rajasthan, since it took place in Udaipur. And for the very first time, this was held in Indore in 1952. So for the first time, the All India Whips Conference, it was held in Indore in the year 1952. So 1952 means in the very first year of general elections to the first Lok Sabha. So who is a whip? A whip is an important member of a political party's parliamentary body, and that person has a central role in flow management in both the houses of parliament and is responsible for discipline within the party. Every political party, whether ruling or opposition, has its own whip in the parliament. When we mention about the functions of whip, an important matter worth mentioning is the anti-defection law. So according to the anti-defection law, members of a political party can be disqualified when they does not vote or when they abstain as per the party's whip. So another question which could be asked related to this topic is constitutionality of the post. Is the office of whip mentioned in the constitution? So the answer is that the office of whip is mentioned neither in the Constitution of India, nor in the rules of the house, nor in any parliamentary statute. So we can say that it is based on the conventions of the parliamentary government. So that is an important point to be noted for prelims. The office of whip is neither mentioned in the Constitution of India, nor in the rules of the house, nor in a parliamentary statute. It is based on the conventions of the parliamentary government. Next we have Pravasi Bharatiya Divas. Pravasi Bharatiya Divas is celebrated on 9th of January every year to mark the contribution of overseas Indian community in the development of India. So why is 9th of January chosen as the date? The answer is to commemorate the return of Mahatma Gandhi. January 9 was chosen as the day to celebrate this occasion, since it was on this day in 1915 that Mahatma Gandhi, the greatest Pravasi, returned to India from South Africa and led India's freedom struggle. So in order to commemorate that, January 9 is chosen as the date for Pravasi Bharatiya Divas. And Pravasi Bharatiya Divas conventions are being held every year, and it started from 2003.